Welcome to Cordell and Cordell's Men's Divorce Podcast, moderated by Managing Partner and CEO Scott Trout, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Hey, welcome back to the Men's Divorce Podcast. I'm Scott Trout, Managing Partner, CEO of Cordell and Cordell, trying to give you direction, guidance, education, as we always do in our podcast. And as I always start us off, just to make sure this is not and cannot be legal advice. We just can't do it. It's best set in a consultation where you can have a one-on-one with people like my guest today, like Michael from Minnesota. That's what you want to do. You go to the website at cordell.com, or you can give us a call at 866-DADS-LAW, or you can schedule your consult right from the website. You don't even have to pick up the phone. Type in your zip code. It'll give you an office nearest you and show you the available times. You can do it in person, on the phone, or Zoom, or any other technology that works best for you. So today, welcome to the program, Michael from Edina outside of Minneapolis.
Thank you, Scott. Happy to be here.
Yeah, thanks. We're going to talk, we were just talking off camera a bit about ADR. What is that? I know oftentimes attorneys will use these words that no one understands, but I think when you break it out, alternative dispute resolution, pretty self-explanatory, but there are some really good details and finer points. But, sometimes you intermix that with, you may hear other words, mediation, arbitration, settlement conferences. It can be confusing, but let's start there, Michael. Kind of tell everyone, what is ADR?
Yeah, absolutely, Scott. So ADR, again, alternative dispute resolution. It's a method of resolving disputes without having the court have to make a decision, right? So often in these cases and in family law cases, a lot of people come in, they can be contentious, they can be high conflict, and people automatically assume and think we're going to try. Right? The judge will need to make a decision. And ADR is there really in my jurisdiction, the majority of cases, frankly, to help parties try to resolve those disputes without the court having to make a decision. And so ADR is the umbrella under which things like mediation, arbitration, those individual processes exist. And so there is a wide range of processes to choose from. And so in that respect, it can be individualized, which is helpful. And really the whole purpose of ADR is to allow a qualified neutral, generally a qualified neutral provider, someone who doesn't have any skin in the case, so to speak, get their hands on the facts, the parties, and see if they can help them reach an agreement, or in some cases, make a decision for them.
And it just is that, it's alternative. And I think it's interesting. Now, I'm curious, in Minnesota, do you have mandatory ADR with every case, or is it just something that people can consent to?
So that's a very good question, because it varies quite a bit from jurisdiction to jurisdiction. In Minnesota, we are a mandatory alternative dispute resolution state. Now, of course, there's some exclusions, but generally speaking, we're a mandatory alternative dispute resolution state. And again, it really does incentivize people to participate, to settle. And that is most times what's happening. In some of the processes here, and I'll go into them specifically, they're seeing around a 75% effective settlement rate, which that's handling the majority of cases. So in Minnesota, it's worked out quite well.
It's huge, because you think about it, I know we're talking generally, and I know there's a lot of questions that you're thinking, okay, that sounds great, ADR, but what does it mean? Does it mean the parties get together with the lawyers? Do the lawyers just get together? Is there a third party involved? Talk about the mechanics, kind of the most commonly how it's handled in domestic relations.
Absolutely. So I've broken it down into three of the most common processes. So the first one is what we call early neutral evaluation. Again, to just continue throwing acronyms out, EN. Right? Early neutral evaluation. And early neutral evaluation can be for social issues or financial issues. And it generally will include 1 to 2 evaluators. Now, in a lot of cases for social issues, and when I say social, I mean custody and parenting, that's going to include qualified neutrals as attorneys, generally family law attorneys, or individuals that have a mental health background. Very commonly, you'll see licensed marriage family therapists, social workers, and so on. In a social early neutral evaluation, both parties are going to be given the ability to share their perspective, their thoughts, and their requests with the evaluators on what they think is best for the children. And, following that sort of, storytelling aspect of things, the evaluators are going to break off and they're going to confer with one another and provide recommendations based on what they've heard from the parties, and in essence, provide recommendations for what they think a court would do, what they think a judge would do, and the law would dictate in terms of, custody and parenting time. And so just to circle back to another question you asked, does that mean that parties have to go by themselves? No, it does not. You can always have the benefit of legal counsel at any of these processes. And it's very common that lawyers are involved. Now, the idea, though, is to keep the power with the parties. The attorneys are there to guide those discussions, remind parties when to bring certain things up that they know are important to them, and things like that. And with that, go ahead. I'm sorry, Scott.
I was going to say, so with the early neutral evaluation, the E&E, I imagine, as we're going to talk later, is this something, there are others, and then we'll talk about mediation, arbitration. This is just kind of a subset where they can pull out some of this evaluation, this custody evaluation, maybe even some of the financial issues away from property.
That's exactly right. It's a sort of a bifurcated process in terms of social and financial. That's why they break it down that way, is it really allows the providers, and you're going to have different providers for different issues. You're going to get the benefit of getting providers that can really give you sort of a truncated custody evaluation without having to go through the full process of months and months of a custody evaluation. They're going to do their best in a few hours to give you that. And following that, they're going to allow you and the other party to talk and see if you can reach agreements. You don't have to agree with their recommendations. And in fact, you and your attorney might talk about it and decide that you don't. But you'll still get the opportunity to give your feedback on that and then talk with the other party, see what agreements can be reached.
So when they do these evaluations, kind of this mini custody evaluation, does it involve visits with you separately from this meeting, with your kids, with friends or family, or those individuals that you've identified that you believe have a significant or may have a significant impact on the decision making?
So in an early neutral evaluation, typically it is a 3 to 4 hour session of time. Basically treat it like a long meeting, where the people involved are going to be the parties and their attorneys, and the providers are going to hear directly from the parties, which again, I think can be really helpful because having a full-blown custody evaluation, it takes time, it takes a lot of money. It does involve those other things that you spoke about, speaking with other people, interviewing other people. However, not all cases need that. And that's not the right fit for all cases. And so most cases, the providers can get what they need in just a couple of hours.
So who pays for it? That's a good one.
That's a very good question. So the parties pay for it. It generally, if it's done, the E&E process is primarily done through the court system here. And so that is done on a sliding fee scale. And it depends county to county. But again, it is far more cost effective than paying an attorney to litigate. But the parties share those costs.
It's interesting. I've not heard E&E before. Obviously, every state's got something different. Missouri may, thinking of a court employee, we have a division of social workers and the domestic relations department, and they can assist in kind of evaluating and providing and structuring parenting plans, custody schedules, making recommendations. And they're social workers typically, or they may have some training, obviously, in custody evaluations, but they're often not psychologists, psychiatrists, custody evaluators in the sense of an advanced degree. Do you often see any of those types of individuals in E&E?
Absolutely. And so with E&E, each county generally has a roster of authorized providers that you can select from. And you're going to see a lot of, like I said, LMFTs, licensed marriage family therapists, psychologists. You are going to see people that have degrees in social work as well, but they're most commonly going to be paired with other degrees as well. So it's a pretty good mixture of both family law attorneys, because family law attorneys can provide that sort of unique perspective of what they think a judge or a county would do, and then also that mental health provider, which can be really helpful for diving into some of the more unique and individual questions that people have, and giving their perspective on it.
So let's transition to kind of what maybe more people are familiar with, and maybe more common in the country and state by state, and that is mediation. I mean, a lot of people, I do consults and they talk right out of the gate, well, are we going to do mediation? Is that something that I can choose to do? Is it to my advantage? Let's talk a little bit about mediation, what the differences are and what the advantages.
Yes, absolutely. And yeah, this is going to be the big one that most people are probably somewhat familiar with. So yeah, mediation is a third party neutral. Again, at least in Minnesota, they have to be qualified under a rule. They are going to sit down with parties and attorneys, if applicable, and have a collaborative discussion, really, to try to figure out what are the issues and how do we get the parties here to craft their own agreement. Mediation really is a bit of a choose your own adventure. And that's why I think it's so widely used, is because it can be evaluative. It doesn't mean just because you're not in an early neutral evaluation that mediation cannot be evaluative. A lot of providers are, again, same branch of family law attorneys that have been practicing for a long time, and mental health providers, or in financial cases, accountants. They're people that understand the issues at hand, and they can give their perspective on and evaluate the case itself, or what they think is going to look good in front of a judge and what isn't. And so it's all being done, again, to allow the parties to craft their own agreement, but also, I think, inject some reality into the situation. It's not uncommon for parties to have potentially unrealistic expectations, or not even have expectations.
Right, or they can be so far apart that maybe tend to be unrealistic. But I talk a lot about mediation from the very beginning in the sense of informal and formal. And I use those terms. I've kind of created that. All right, informal, let's get together with opposing counsel. We don't need to hire a neutral. And let's kind of do our own mediation, see where we are, and see really how far apart we are, see how realistic their expectations are. Now, in that sense, the danger of my informal mediation is confidentiality, right? So if I don't formally, in St. Louis County here in Missouri, we do have a requirement of mediation. Once you engage in that, it is confidential what's in there. My informal is not. So there's that balance. So the confidentiality part matters.
Absolutely. And I think you've touched on a big sort of overarching positive as to why I think ADR is a good thing, is helpful in a lot of cases, is it is confidential. And specifically in mediation, you cannot leave the room and then go to the judge and say, well, at mediation, so-and-so said they would agree to this, and now they're saying this, right? That would undermine the process entirely. So it does allow a safe space for people to share ideas without being concerned that they can be used against them. And again, another thing that I think is important to consider is it is confidential. The facts are the facts, though. So that can also provide some background for what you may need to do if you are going to continue to litigate in terms of discovery. The facts are the facts, but that those are not confidential. And so in that regard, it can help shape potential discovery in the future as well.
Yeah, and it is big. I mean, I don't want them using my offers in front of the judge, or maybe my client's unreasonable position from their perspective of what to do, or playing money off in exchange for custody. And I don't want the judge being influenced by that. And so I get it. It should be to facilitate the best chance at resolution. You have to feel free to say what you need to say without retribution. Or, I think that's such a huge, important part of understanding why it can be an advantageous activity, if not, albeit mandatory. So, which leads us to arbitration. So a lot of interesting, I think people know arbitration because you can find that little word tucked into a lot of contracts. It could be tucked into your rental agreement. It could be tucked into something you hire a contractor. There's an arbitration provision. What is that?
Yeah, I was going to say, go ahead, everyone, and take a look at your cell phone agreement that you've signed or anything with the cable company. There's likely an arbitration clause there. So arbitration is a little bit different from what we've been talking about in terms of, we've kind of been talking about collaborative, cooperative processes. This really is not one of those. This is more like an informal hearing or trial in a lot of ways. Again, the third party neutral is selected. They do have to be qualified, but what they're going to do instead of facilitate a discussion is most commonly they're going to get each side's position on an issue, get each party's position on an issue, whether that be through written position statement or submission or testimony or evidence. It depends. And they're going to make a binding decision on those issues, very similar to what a court order would look like. And the best example I can give to help people understand is in Minnesota, we're commonly putting arbitration clauses in terms of personal property, household goods, and furnishings, right? The courts in Minnesota typically do not want to go through a long personal property list and decide who's going to get what furniture out of the home, things like that. That is most commonly what I've seen in domestic litigation purposes. So it is a little bit different. It's not as collaborative. It's often a last resort before having the court have to step in.
I think it is. I mean, there's dangers. Before I was practicing in family law, this is my 31st year, I did do some civil litigation, and we oftentimes would agree to some arbitration because we knew we had some boundaries, and we knew that our clients could live within those boundaries from A to G, and we just couldn't find that common ground at letter D. And so we were trying to do that. And I never have used, interestingly, arbitration in my practice in family law. It's kind of rare, although COVID, I tended to see that happening far more often during the heart of COVID in 2020 and early 2021, because people were so anxious to get resolution that courts couldn't get there. So they're like, all right, let's just submit it to binding arbitration. I don't know what your experience is with arbitration, though, and especially in COVID.
Yeah, I think I do think that I've seen it in terms still primarily applicable to a lot of personal property or sort of off disputes like that. I have seen more cases going to arbitration, and I've talked to my colleagues and they're noticing the same things. And so what used to kind of just be a clause we would put in a decree without the thought of ever having to use it has in fact been quite influential, and it does require a little bit more thought before you just start including things like that, because the courts are busy. They are more backed up. It does take more time to get before a judge. And so certainly I think COVID's another way that COVID has influenced the practice of our area of law. Absolutely.
Yeah. And I think, as I look through and we talked, you mentioned earlier some of the advantages of doing it. There is some certainty. I always say, you might as well have a plumber up as a judge. He doesn't know you. He doesn't know your kids. He doesn't know really your life other than the minimal time that you have to present your case, in maybe 8 hours and maybe 16 and maybe a couple of days. And imagine, the gravity of that decision, and you're leaving it in the hands of someone you don't know, and you really aren't in necessarily control. And you do have a little bit of control. You can say yes or no to the outcome in mediation or early neutral evaluation, right? Absolutely.
And I think that's a really nice segue to just discussing what are the advantages. Why are we so, at least why am I such a proponent of it? Why is it so effective? You're absolutely right. Imagine trying to let someone that you don't know into some of the most intimate parts of your life, raising your children and what's going to happen to them, and some of the most important parts of your life. And really, when you break it down, you're getting a few hours on the stand, most commonly. It's a daunting task for anyone. And as attorneys, it's something where, yes, if it's necessary, we do it. That's what we do. However, there's a lot of most cases where it's going to be more advantageous to let the parties not have to, they know their children best. Let the parties be the ones to have that control. And again, one thing that is also, I think, really advantageous is it is far more cost effective. It's going to reduce legal fees. And also the fact that it can be binding. Even mediation and early neutral evaluation. Generally, what's going to happen is if you and the other party are able to reach an agreement, that provider is going to draft up what that agreement is, and that's going to become a binding contract that you can enforce in court if need be. And so what you've done is really cut the line. You've cut the line in terms of having to get a pretrial and a trial date and prepare for trial in a very efficient, effective way that allows you to keep the control in your hands, as opposed to, like you said, trying to inform a judge that does not know you in a short amount of time.
Yeah. And I know that the temptation is people and guys listening to this thinking, well, I don't need a lawyer. I'll just go do that and save the money. But I can tell you, having just done some mediation, we prepared for that mediation like it was a mini trial. Exhibits, exhibit books, preparation in terms of what we were going to be doing, our offers, even some of the statements our clients were going to be making. It is a storytelling process, and your choice of a lawyer is as important for that mediation as it is for even the trial. And I look at that whole picture. So it is critical that you have legal counsel. I really believe it. You can choose to do it without it. I'm against it. I like informed decision making. If I'm going to make a decision about a surgery, I just don't want the list in front of me. I want my surgeon there to ask questions. That's kind of my thought.
Yeah, I would absolutely agree. I think that you have to keep in mind these processes, they're guided by individuals that are trying to figure out make recommendations and discuss things based on what the law says, based on what they think a judge would do. Well, guess what? That's also lawyers' realm. That's where we know what the law says. If there's an agreement that's being proposed that we don't think a judge would necessarily consider, or that it's unlikely that a judge would order it, that's the benefit of having legal counsel there. And also, as you said, there's so much preparation that goes into mediation, talking with your client, ensuring that they're able to address everything that they would like to, so they don't, they're not thinking they forgot something. And in terms of financials, exchanging financials, putting together documentation, all of those things benefiting to have legal counsel. And so while these processes can be effective, it is something that still is should be done with legal counsel and with legal advice.
Well, good stuff, Michael. Hey, thanks for providing the input on all of the different options available to clients going through it. So appreciate it.
Yeah, absolutely. Thank you very much, Scott. I appreciate your time.
Well, check out our YouTube channel, podcasts, virtual town halls, all of our information, things in previous, just like this, are sitting out there. You can also go to Apple iTunes and subscribe to this podcast and get alerted every time we bring a Cordell and Cordell attorney on board and talk about issues pertaining that are relevant to you before, during, and after divorce, and some considerations. And so what do you do with this? You take this, go get a consultation, talk about it. Go find a lawyer that practices exclusively in family law and say, I heard Michael talk about early neutral evaluation. Can you tell me more about it? And that's why we do it. So check us out, subscribe, check out our social media and our YouTube channel. And if you haven't attended one of our virtual town halls before, check it out next in the September one, where you can log on for 30 minutes, get questions, give them out, and get answers right then and right there from a panel of attorneys. So it's free. All you got to do is check it out and register. 30 minutes during the afternoon, our virtual town hall. So until next time, have a great week.